Welcome back to Lost That Channel. My name is Anton Vieltsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. In this video, we're going to focus on an exception to a warrant requirement called consent. In fact, a few months ago, I published a whole series of videos dealing with vehicular searches without a warrant. One of those videos focused on consent. This is going to be an addition to that series. We're going to talk about a 10th Circuit case that deals with possession of methamphetamine with intent to distribute. And of course, the appeal focuses on whether there was consent given by the defendant to the DA agent when a search was conducted of that person's luggage on a train. In this video, we'll be discussing United States versus Delgado-Salazar, which is a 10th Circuit case from March of this year. This is a relatively short case, but it gives you a good overview of what we're looking at when we're evaluating consent to search. So here's what happened. The question in this case is whether there was voluntary consent of a search of a luggage aboard of an Amtrak train. This individual was charged and later convicted under 21 U.S.C. 841. This is a statute that you should be familiar by now. I have plenty of videos dealing with this statute. You should be familiar and you should recognize this number. This is possession of methamphetamine with intent to distribute. At the end of the day, there was methamphetamine found in the luggage of Mr. Delgado. He was later sentenced to 12 months and 1 day. Why is that number important? You might have heard in other cases, there's often 12 months and 1 day. What's up with this 1 day? Well, here's the thing. If an individual gets a sentence of 1 year or less, he has to serve the full time. But if the sentencing judge imposes 12 months and 1 day, anything over 1 year period, the individual receives good time credits. So 12 months and 1 day will effectively be somewhere over 9 months of actual custody time. But let's go back to the case and talk about consent. When we're evaluating consent, we're looking at 3 factors. The consent must be unequivocal and specific. It must be freely and intelligently given and not a result of implied or express duress or coercion. Here's what Mr. Delgado argues on appeal. He asserts that there was confusing nature of questioning posed in incorrect Spanish. The conversation between the DEA agent and Mr. Delgado was in Spanish, but it was rather confusing. And his second argument is there was coercion because the DEA agent misrepresented himself as a police officer simply checking the train. So let's go into the first assertion. Here's what the court says. The Court of Appeals has to rely on the hearings conducted by the district court. So when we're in appeal, we're not arguing these facts anymore. We're simply looking at the record, at the transcript. Here's what we know from the transcript. The officer asked Mr. Delgado, "Me permite registrar por contrabando?" Now, it's not the best Spanish here, but Mr. Delgado answers, "Yeah." And there's some confusion, whether that "yeah" means yes in English or "yeah" meaning in Spanish now. Now, of course, when we're in the Court of Appeals, they're evaluating this, but essentially they have to rely on the district court. And the district court said, with which the Court of Appeals agrees, that there was not vague, unclear, or confusing questioning. And because of that, his consent was unequivocal and specific. The second argument about the misrepresentation, we have to look at the coercion. But here's what the Court of Appeals says. The DEA agent was the sole officer at the scene. He did not physically mistreat the defendant. He did not employ weapons or violence or threats. He wasn't aggressive in his tone. And there was nothing in defendant's physical or mental condition that made him particularly vulnerable. And because of that, the court says when we're looking at all these factors that relate to coercion and duress, we just don't see it. And because of that, Mr. Delgado loses in the Court of Appeals. But here's some final note. To set aside a finding of fact as clearly erroneous, appellate court must possess a definite and firm conviction that a mistake was made. So if you think about it, that is a very difficult standard of review that the defendant has to overcome once they're in the Court of Appeals. And in fact, here's what the Court of Appeals says, and I quote, "Like most appeals presenting factual challenges, when we're looking at simply the facts, the high hurdle the standard of review presents is simply insurmountable in this case." Meaning that the Court of Appeals has to focus on the record, on the transcript. And because we're focusing on the transcript, it is difficult to win these cases. So here's the lesson you should take from this case. Never consent to any searches conducted by the police. And in fact, just don't consent to any searches, ever. You might not understand whether the police officer is an actual officer, or maybe the DEA agent, or maybe the postal worker. Whoever that government official is, do not consent to searches. If you enjoyed this video, please click like, subscribe, hit that bell notification button, so next time I post, you'll be first to know. Thanks a lot.